Fort Lauderdale dentist
gunned down by a hitman.
Mastermind murder trial.
Arrest in the murder case.
South Florida dentist Charlie Adelson organized the
Life imprisonment.
The mother of the convicted suspect has now been arrested.
Welcome to Unshut Cases. I'm the host of Unshut Cases, Dan Taft. On today's episode, we have an incredible attorney out of Miami, Florida, Vanessa Vasquez de Lara, the founder and owner of Vasquez de Lara Law Group, divorce law, paternity, prenup, custody, president of the Coral Gables Bar Association, and founder of the Supreme Scholars Foundation. Vanessa, welcome to Unshut Cases. We're so happy to have you.
Thank you, Dan. I'm happy to be here.
Awesome. And today we are discussing a very interesting, very tragic case, but with a lot of angles, a South Florida case that happened about 10 years back and has kind of continued running since then in terms of discovery and new information coming to light. This is the Dan Markle case, very high profile. Dan Markle was a lawyer and law professor at Florida University, killed in 2014 in a murder for hire motivated by child custody issues following a difficult divorce. His ex-wife, Wendi Adelson, was also a law professor at Florida University. Daniel was shot at his Tallahassee, Florida home after being stalked all morning by his eventual killers, Sigfredo Garcia and Luis Rivera. Garcia and Rivera had ties to the Latin Kings, alleged they were hired by a third party on behalf of Wendy's brother Charlie and Wendy's mother Donna so that Wendy could relocate to Miami with their children. Daniel and Wendy were granted 50-50 custody after the divorce initially in 2013. Daniel won an order prohibiting her from relocating. Charlie, Donna, Garcia, Rivera, and the middlewoman, Catherine Magbanua, I think I'm pronouncing that correctly, was the mother of Garcia's children, was dating Charlie at the time, were all eventually convicted of murder in this case. So the actual crime itself took place in Tallahassee, but she was trying to set this whole thing up to go back down to South Florida to Miami.
So it is alleged.
Alleged.
There have been no charges brought against Wendy herself. Her brother was convicted and her mother is scheduled for trial. The actual killers were convicted, but Wendy has not been charged. And although it's, obviously it been inferred by everyone that somehow she was a part of it, she's obviously vehemently denied that she was a part of it. And she has the children now.
You have no knowledge of it.
I have no knowledge.
In all the years this has been pending.
In all of the years this has been pending.
Your brother has known who killed your child's father, and you didn't know.
I did not know.
So as a divorce attorney in Miami, can you just kind of give us some insight into the initial divorce between Dan and Wendy? How did that happen initially and kind of set everything in motion in this case?
So the reality is that, from what I've gathered, it was a pretty normal kind of run-of-the-mill divorce. I don't know that there were any specific allegations that that would have ever told anybody that this was a possibility. But the sad reality is that, family law cases are the really emotional, really difficult, personal type of cases where if anything can kind of go off the rails, it can. So by the fact that they received, equal time sharing back before this was actually a presumption. So our Florida laws changed for equal time sharing, where now there's a presumption that both parents are equally able to exercise equal time sharing. That changed last year. And before that wasn't the law. So the courts needed to basically analyze the situation, the factors, the time-sharing factors that are in the Florida statutes in order to determine, okay, what is in the best interest of the minor children? And the court would then make a decision based on the analysis of those factors. So in this situation, the court analyzed the factors, and there's about 14 of those. So they're a little bit extensive. And the court determined that both parents were perfectly adequate. I mean, they're both law professors. So my assumption is that their schedules are pretty similar, that they both had the ability and the capability to have equal time sharing. I don't know if you're familiar with Tallahassee, but Tallahassee is basically FSU and kind of like the seat of our government, but there isn't a lot more there. So if your family's not there and you're now divorced, and the only reason maybe that she moved there was to follow her husband and got a job there just for that purpose, once that's no longer there, that's sort of a situation that you're trying to get out of. And that's really a lot of relocations that our office deals with sort of relate to that. People who move to South Florida for, one spouse's job and then they end up getting a divorce. And then it's kind of like, okay, but now I want to go back to where my family is, where I grew up, where I'm from. And that can be really difficult to navigate because there's not a good meeting point. It's not like, okay, well, I'll allow you to move to Orlando, but I won't allow you to move all the way to Miami. It's kind of, you either allow a relocation or you don't allow it. And when you have equal time sharing, it's a very difficult burden to overcome that relocation should be allowed.
So Daniel Markle was a lawyer and law professor at Florida State University. And then his ex-wife, Wendi Adelson, was also a law professor at Florida State University. That's Tallahassee. How did being granted 50-50 custody of their two sons lead to Wendy not being able to move them to Miami? Because you kind of just touched on that, but
sure.
Can you kind of get a little more, more granular on that?
Absolutely. So Florida law, the way that a relocation works is whenever there is a court order of time sharing and a parent wants to move more than 50 miles from wherever they lived when the order was entered. So if I live in Miami, but my ex lives in, let's say, Fort Lauderdale, then my ex wouldn't be allowed to move more than 50 miles from Fort Lauderdale without an order of relocation. And that is 50 miles. The formal term is as the crow flies. That means it's a direct line of 50 miles. So it's not 50 miles in traffic. It's not 50 miles, in any way, but literally a line that you draw. If you remember your algebra class, it's a radius of 50 miles. And that's kind of like the circle that you can move. So whenever you need to move more than those 50 miles, now you're talking about that you have to either have permission from anybody who is entitled to time sharing, because sometimes there might be a time sharing order that is not for a parent, unusual, but sometimes. So you need permission from that person who has that order time sharing, or you need a court order. And a relocation becomes a case similar to a divorce, sometimes even more contentious, because sometimes we'll see parties who amicably agree to get a divorce, and then they come back to us, a year later and say, I want to move. And the other side is like, absolutely not. You're not moving my children where I can only see them at Christmas. So you have to then file for relocation. And in Florida, the way that it works is that these cases are afforded an expedited hearing, and you're supposed to be able to get a court hearing within 90 days of filing that petition. Because obviously if you're trying to, if you're saying that, well, I got a job somewhere else, no job is going to hold it, for a year while you get a relocation trial. So our statute does allow for sort of an expedited procedure where you can get a hearing in 90 days. She got her hearing, the judge denied her relocation. And this all kind of stemmed from that situation where she petitioned the court for relocation, and that relocation was denied. There's a set of factors that have to be analyzed, and the court goes through those. So it's a set of factors for time sharing, for an initial case when you're getting divorced or when you're setting up that initial parenting plan. And there's another set of factors that kick in if you ever ask the court for a relocation. When the court analyzes that, they basically have to analyze it and say, okay, this factor favors one parent or the other parent or neither parent.
Right.
And from the fact that her relocation was denied, it appears that, when the court analyzed the factors basically, they didn't fall her way, and the court denied that relocation. And what that means is basically, you're stuck. You're stuck like Chuck, and you can move 50 miles from where you were living when you got divorced.
Okay, so that makes a lot more sense, and getting all that insight kind of to Florida law so that we kind of understand the setup here and what this initial conflict kind of, spilled out from.
Yep.
Do you think Dan filing a motion that would have prohibited his mother-in-law from being unsupervised with the children may have contributed to everything else that kind of played out from here? Obviously, it's a horrible case, tragic case, hitman for hire, but that moment or that sort of move where he prohibiting the mother-in-law from being unsupervised with the children, can you just kind of speak to that specific angle of this whole thing?
I mean, like I said, family law is so emotional that anything, that sort of sets off one side or the other is potentially has that, has those sort of like the repercussions and the reverberations that might have been sort of like the straw that broke the family's back.
I would never do something like that.
Wendy's boyfriend at the time told police that her family had come to hate Markle for blocking Wendy and their kids from moving away.
The family desperately wants her back in South Florida. Mother, father, and she has a brother. They hate Danny in a way I've never seen this kind of obsession.
And they decided, okay, this is untenable. This is not ever going to get better. And it's unfortunate that they felt that that those were the steps that they needed to take. We see this frequently where there might be motions for the boyfriend not to be unsupervised when it's, the ex-wife, or a family member, or, things of that nature, for situations that are real and situations that are perceived. Because obviously at the crux of the matter is the parent who might be petitioning isn't there when things are happening. So now you're having the children sort of being the reporters of whatever's happening. And I don't know if you have kids, but I've got kids. Now they're full-grown teenagers, 15 and 18. And children do not think the way that we think. Adults sometimes don't think the way that we think. But I frequently see it where children will tell a parent something where if it was an adult, you'd be thinking, okay, they're purposely not giving you the whole picture.
Right.
But it's a child where they may not capture the whole picture. They may not understand the whole picture, or to them, it might not even be an important detail that is, an important detail to an adult. And some of the studies and research shows that children also, to some extent, try to sort of side, I don't think is the right word, but kind of align with the parent that they're with. So we've had cases where a child will tell mom, I don't want to go to dad's house, and will tell dad, I don't want to go to mom's house.
Right.
And it's not that there's anything actually wrong on either side, but it's that the child is sort of like, the parent gets so happy or, like kind of like interested when the child is sort of siding with them, or, that sometimes the kids kind of become unwitting pawns in this situation. So potentially, I don't know the details of the motion, but potentially he heard about something that happened, or there was some sort of situation where he may have had some information, not all information. For all I know, he could have been present when whatever went down. But we see this quite frequently where parents will come in and say, well, my child said this, my child said that, and we have to file something. We got to get something in front of the judge. And I'll be like, listen, let's maybe take this with a grain of salt. Maybe let's have the child talk to a therapist, a neutral third party that can help to kind of ascertain exactly what is the situation that's going on before, you kind of go out guns blazing. Some accusations are so serious that kind of have to take action immediately. But the fact that he didn't ask for there to be no contact, and he asked for the contact to be supervised, would indicate that it wasn't an allegation of sexual abuse where you're going to say no contact, but maybe she spanked the kids and he's not okay with that. And, he thought, I don't want her to be unsupervised with my kids, so there's just so much that happens in these type of situations that when people are not getting along, it's incredible how you think as a jar of beads and it was full of love in the beginning of this marriage. It's like, red love beads that at the end are like black hate beads. And it's sad when you have kids in the middle that be able to observe a good co-parenting relationship between their parents. Yeah. But that absolutely could have been the spark that led the match that, unfortunately led this entire situation to blow up.
From what we know, how did Wendy's family, and I know Wendy was not convicted, her brother was, and then you said her mother is actually still undergoing the whole trial proceedings and everything. I guess they go about arranging this shooting. What were the kind of the details there in terms of your perspective?
So, it appears that they had a connection with somebody who had a connection with somebody. It kind of just went on from there. There was a personal connection between, I think it was the mom or the girlfriend of one of the killers. And that kind of like set off that domino effect that led 3 people to be convicted for this crime as the actual murderers in the murder for hire plot.
What is your, and I know it's purely speculative, but in terms of the fact that Wendy is somehow has sort of slipped through this and is not being convicted where everyone else was. I mean, and I know it's hard to say, do you think she was involved? Do you think that is right or wrong? But what is sort of your take on, I mean, you cannot separate her from this story. So how do you sort of perceive her role, I guess, in the narrative here? And,
Interesting,
no,
because we've seen some of these family members who are taking the situation more personally than the client. We've seen a parent who is like, pardon my language, but kind of goes balls to the wall on the daughter's ex. And it's almost like the daughter's like, I just want to get this over with. I just want to get divorced. Sometimes it's the family that is almost more passionate about sort of like that revenge. So I could totally see a situation where the family sort of like decided to, well, Wendy isn't able to do anything about this, so we're going to take care of this problem on her behalf. I would like to think that that's a pretty big kind of thing to undertake without having a knowledge, a certainty that it would be appreciated or, like needed, you know what I mean? Like, but
sure right. It was something she would have wanted, maybe, or
exactly. And you never know what happens behind closed doors. And we've had situations where there's been allegations that we believe or we can demonstrate to the court are false allegations of domestic violence. But sometimes there are people who believe in an alleged victim no matter what. So I don't know that that was the situation here, but we don't know what she told her family or what, she may have sort of elaborated on or embellished on to kind of like get her family to really rally with her. And so they may have thought that they were doing this for her benefit because of things that maybe she said. So that's a really hard situation to sort of find yourself in, that your family just undertakes this without you. But based on my experience, I could see that.
It's been 10 years now since the murder. Things seem to be coming to an end with the family sentencing, although you did mention, I think Donna, the mother, has not been sentenced yet. In terms of that decade-long run, is that a normal timeline for a case like this, or is it longer than normal? I mean, what is your take on just kind of that it took 10 years to get to these convictions?
I mean, the reality is that I can't speak to the criminal aspect of it. Is you always look at, the inner circle, right?
Yeah.
And when you have any kind of murder for hire, everybody, I'm sure, had very good alibis, so I'm sure Wendy was very far away. So was the brothers. Mom is back at home in Miami, so I do believe that those cases are much more difficult for the police to be able to put together and build, because the immediate suspects that you got to eliminate, I would imagine, are all well alibied. It is unfortunate, but it's one of those things that those type of investigations, they definitely carry out for years and years. I can tell you from my personal experience, my brother was murdered in 2020 and there still have been no arrests at all. We've been advised that there's some things of interest, but it's now been 4 years and they've been unable to make any arrests in that situation. So from my personal experience, I can see that it's something that these investigations can really, really drag out. And it is an unfortunate circumstance that we do see in murder investigations sometimes.
Very sorry to hear, about your brother. I knew obviously there was the foundation and everything, but that's tough.
Thank you.
The Markle Act itself, I know that there was, that was an act that was passed after this. Can you kind of tell us a little bit about that, how it came to be, and what impact the Markle Act in the state of Florida could have moving forward?
Sure. So basically what happened is that the Markle Act allows for grandparents to be granted visitation when one parent causes the murder of the other parent. So in this situation, right now, Wendy has not been charged. So this actually does not apply to Dan's parents.
Okay.
I would assume and imagine that they believe that Wendy is involved, and they believe that if Wendy is ever prosecuted or charged, that, that this would sort of kick in. So it's a very tiny, narrow statute that grants for these grandparents' rights, where Florida really doesn't have any grandparents' rights. So, in that very niche situation, if Wendy were to be prosecuted and convicted and the children were minors, the grandparents, Dan's parents, would then be allowed to have time sharing with the minor children. Right now, they don't have any time sharing. They're not allowed any time sharing because Florida does not grant any kind of grandparent rights against a parent's wishes. So in a situation where one parent is found to cause the death of the other parent,
Right.
that the deceased parents, so the grandparents on that side, would be entitled to time sharing. And they can petition the courts to seek that time sharing in order to be able to see their grandchildren. And the act, went through almost unanimously. And, and it was something that, although it's not common, fortunately, it's something that you could probably expect to see typically in domestic violence situations where perhaps one side causes the death of the other. And this would allow those grandparents to be able to seek that time sharing.
Speaking to the aftermath of this whole thing, after the murder, again, Wendy, to your point that you brought up, was not charged with anything. She changed the last names of her children to cut off contact between them and the paternal grandparents. As you mentioned when we discussed the Markle Act, the Florida grandparent visitation laws are some of the strictest in the country, making it nearly impossible for them to visit their murdered son's children. In this case, I think is what we're talking about, right? And then Florida legislation in response, this is the Markle Act. The whole point of that was to make it easier for grandparents to be granted access. But in terms of the sentences that have been handed down to the killers in this case, can you speak a little bit to those, if you feel like those were fair here? Were they too light, too much, or just anything that you can kind of speak to in terms of where we are now with this case and kind of how everything came out of the courts?
Sure. So, I mean, the actual, I guess you'd call them triggermen, were convicted. My understanding is that they received life in prison without the possibility of parole, just on the murder charge. I know that at least one of them, that was the finding. There was another 30 years added on for, good measure. I guess in case you always have, people always ask, like, why are there concurrent charges when one is going to send you to death penalty or one is going to send you to life in prison? Why do the prosecutors bother with extra charges? The reality is that sometimes convictions are overturned, and you might have an overturned conviction on one charge, but not on others. So that allows, to make sure that you're sort of kind of covering your bases, that you're covering all the different crimes have occurred. So in this situation, the charges were not only for the murder charges, but also for conspiracy to commit murder. And my understanding is that there was a conviction on the murder, life imprisonment, plus additional time for the conspiracy charges.
Vanessa, again, thank you so much for being here on Unshut Cases with us today and just outlining this case and getting into really granular detail. I learned a lot. I think the audience learned a lot. Again, for anyone who needs an incredible divorce attorney, paternity, prenup, custody in Miami, Florida, Vanessa Vasquez de Lara, founder and owner of Vasquez de Lara Law Group. Vanessa, again, thank you so much for being here on Unshut Cases with us.
My pleasure, Dan. Thanks for having me.